Well, good afternoon, everyone, and welcome to this event that is organized by the Hansard Society and by the Bingham Centre of the Rule of Law. My name is Jeff King. I'm a professor of law at University College London, and I take a great interest in the topics that we are looking at today, policy in the process of making statutory instruments, among other forms of policymaking, whose scrutiny goes before Parliament. So I'd like to begin by indicating that this session is taking place in the context of ongoing events by the Hansard Society and by the Bingham Centre for the Rule of Law at looking at these issues. So in particular, at the moment, the Hansard Society is in the midst of an extensive delegated legislation review in which it's examining the way in which it is sometimes too easy for statutory instruments to pass through Parliament with a substandard array of supporting documents that would help MPs and peers scrutinize those instruments effectively. And for its part, the Bingham Centre has recently published a report in October of last year that examined 18 months of COVID-19 legislation, a rule of law analysis in England that was authored by Katie Lyons, which provides quite a bit of information about defects in the rulemaking process or perceived defects in the rulemaking process during that time. So the combined work of these institutions has shown that we're at a crossroads at which we need to look at the effectiveness of parliamentary scrutiny of statutory instruments that are laid for scrutiny, as well as to look in particular at the role of evidence in that process. And that is what takes us to our event today. Dr. Tom West and Katie Lyons have put together an incredibly distinguished panel of speakers, and I'm very delighted to host them. They include Justin Matters, MP, Stephen Gibson, Baroness Bakewell, and Mr. Selvin Brown, each of whom will speak in turn for about 8 to 10 minutes, and I'll introduce them with their titles at that time. And then the audience will be given the chance to participate, of course, in the event by posing questions through the Q&A function. And audience members will also be allowed to express a preference that a question posed by someone else be answered first. They can upvote a question, in other words. So we'll get around to that part of the event in about 40 minutes. First, we'll hear from each speaker for between 8 to 10 minutes. And we'll be beginning, with Mr. Justin Matters, the MP for Ellesmere Port and Neston, who is presently Shadow Minister for Employment Rights and Protections. And quite importantly for the context of this event, was a former Shadow Minister for Health and Social Care until December of 2021, and so played a very important role at scrutinizing many of the instruments that came through Parliament in the period of us dealing with COVID-19. So I'd like to hand over to Mr. Matters just now. Thank you very much.
Well, thank you, Jeff, and thank you for inviting me to speak today. As you set out, I was an opposition spokesperson during the pandemic, and it wouldn't surprise you to learn there are many things I believe the government could have done better during the last 2 years, but as we've only got an hour set aside, I'll confine my remarks to the delegated legislation elements of the government's response to the pandemic. So I'll say from the outset that as a party, we took a strategic decision that the responsible thing for us to do in a national emergency was to support the government when it came forward with measures that it was considered necessary. Whether it was that decision that led to some of the issues I'll talk about, or whether it was down to the urgent nature of the regulations, or whether it was because the government have an inbuilt majority on every delegated legislation committee, is no, that's something we can talk about this afternoon. But I would say about the pandemic that what I would consider to be the gold standard of scrutiny, the level of information we were provided with just fell very far short of that on just about every occasion. So as a shadow health minister, I was called upon at times what seemed like a weekly basis to speak for the opposition on statutory instruments, which in turn loosened the lockdowns, tightened them up again before regionalising them into tier systems, as well as a host of other regulations that dealt with things such as face coverings and self-isolation. In the early days, these were actually often held in the main chamber, with just about everyone except the front benches contributing virtually. that had the advantage, I think, of having far more backbench contributions than you would normally expect in such a setting, but also meant there was little opportunity to intervene on the minister. So I think the facilitation of the virtual parliament was a fantastic development that did enable some accountability and transparency. It also, I think, rather let ministers off the hook, and I say that in relation to all proceedings that took place in the virtual parliament. But the majority of matters that I went through, though, were in committees in the traditional sense, and most of the time members were not encouraged to attend because of the risk of transmission. So most of the time it would just be myself, the minister, and a handful of other MPs. In my view, the best way to challenge ministers on delegated legislation is through a series of interventions being put forward by a range of members. So that was something that I think we didn't have the benefit of during this time. Of course, I'm aware many statutory instruments passed without any comment from backbenchers, but I'm sure, given the importance of these, that we would have had much more challenge from ordinary members of the committee if they had been able to attempt to attend. And obviously, as we moved on, we did actually have more instruments in the main chamber, and I think that seems to be now the convention, that is how these will be dealt with. It does lead me to one of the main concerns in regards to scrutiny, is in that although we're now debating regulations before they become law, certainly in the early days of the pandemic, they were debated often weeks or months after they had become law. And of course, while some of those were necessary because of the emergency situation, it does seem on occasions there was no objective reason why that had to be done, why those regulations needed to be put in as a matter of urgency. It raised an interesting point, which I never really got to the bottom of, what would have happened to everyone who received fixed penalty notices under these regulations if those regulations had not been subsequently approved. And the problem also manifested itself in the timing of regulations being published. I recall the one on the Rule of Six being issued 15 minutes before it came into law. That was the first time it appeared on the government website. And I don't expect any police officer, let alone the public, to be able to comply with that, given the way it was introduced. And this delay, continual delay, did lead to some bizarre situations. So on one occasion, we were debating model villages, zoos, safari parks, and aquariums closing down because there was an oversight in the original regulations. But we'd already reached a point where those regulations had been superseded by new ones, which were to do with opening up parts of the economy again, including all those facilities. So we found ourselves in a ludicrous position of debating on the floor of the House regulations, closing down places that had actually already reopened. On one occasion, we were debating regulations which had not only been superseded by the next set of regulations, but by two more sets of regulations. So we were often behind the curve. Another occasion, we debated regulations in September that were introduced in July. They dealt with further relaxations, and the explanatory note said that the fall in transmission rates made this possible. But by the time we got to the debate, rates were on the rise again. It was extremely difficult to understand how we could have a proper debate on something that we knew factually had completely changed. On the other side of the coin, we know that the limit of 30 on weddings lasted for 2 weeks before it was reduced to 15. Now, either that was an oversight in the first place, or some scientific advice changed in that 2-week period. We never got an answer to that. I suspect that we never will. So this all shows really the difficulty we had in trying to obtain clarity about which measures individually or collectively were likely to increase or reduce transmission rates. We were not able to see the minutes of SAGE meetings at the start, and often there was, when we did see them, there was very little correlation between what they were saying and the measures that we were seeing introduced. Sometimes there was no statement in the explanatory memorandum that it had even been considered by scientific advisors, and sometimes there was not even a declaration that it would have an acceptably small impact on transmission rates. Often what SAGE were recommended didn't make it into regulations. The low rate of SSP that they raised is a classic example of that. And I would say on the whole, the memorandums we got for the instrument did not provide the level of detail and explanation we would expect. As we know, the lockdown regulations required there to be a review of their effectiveness every 21 days, and then it moved up to every 28 days. But and that was important because the Secretary of State had a clear duty to terminate any regulations that were no longer proportionate or necessary. But despite repeated requests, we never actually got to see what these reviews were. And I think eventually we came to the conclusion that there wasn't a review in the sense that there was a document that we could actually see. This made it difficult to challenge decisions that were made about when it was the right time to ramp up or ramp down restrictions. And of course, when we moved into the tier system, whilst there were some criteria set out about how that would be allocated in terms of infection rates of admission to hospital and other data, it still was very opaque about how you would move from tier 2 to tier 3 and likewise. It was simply said that if there was a significant rise in cases, but we never actually got to the bottom of what significant meant. A lack of impact assessments was also a common theme. Obviously, these regulations had massive impacts on individuals' lives. But we also knew that there was a question about the disproportionate impact on BAME communities of fixed penalty notices. And again, there were no equalities impact assessments on that. And this was quite an important issue in the sense that actually a number of the regulations increased the level of fixed penalty notice and introduced escalators. There was never an explanation as to why that was necessary or indeed what the impact would be on specific communities about that. I'll just briefly talk about face coverings. That was another saga. They were amended on numerous occasions, adding lists of relevant places where face coverings were required. But these indoor settings that were added to statutory instruments were not fundamentally different in any way from the ones that were on the list previously. So it wasn't clear whether these were being added as to correct oversights or because of a change in scientific advice. And actually, we had half a dozen different regulations adding areas over a 4-month period between June and October 2020. Indeed, the Secondary Legislation Committee actually commented on the number of corrective statutory instruments that were required because of the errors in some of the instruments. A couple of final comments. The Rule 6 was another area where there was a complete lack of clarity about why it was 6 people who could gather and no more or no less. And I remember Grant Shapps saying that it was an arbitrary number, which made it very difficult for us to have any meaningful dialogue about whether that was the correct number. There's also a contradiction between what was done in England, where children were included within the 6, and places like Wales where they were not. And finally, I think we'll have the same issue with the 10 p.m. curfew for pubs, because we could never really get to the bottom of why it was 10 p.m. The only evidence that I saw was that actually everyone piling out of pubs at the same time would increase the risk of transmission rather than reduce it. So in conclusion, I don't underestimate for a minute the difficulty in an unprecedented situation that the government had in translating medical advice and scientific modelling into regulations that were not only enforceable but also effective. But I would say the urgency of the situation did often mean it was very difficult to spot what the evidence or even the rationale was for many of the measures that were introduced, aside from the basic principle that the further you keep people apart, the less likely it is that they will transmit the disease. But given the draconian nature of the regulations, I think in future we need a much more transparent system for members to question scientists on specific measures before they're actually introduced into law.
Thank you very much for that incredibly enlightening contribution that only someone at the coalface of scrutinizing these instruments could give. I'm very grateful for that. We next turn to Mr. Stephen Gibson, a lecturer in microeconomics at Birkbeck University and director of RegWatch Europe, and importantly for this occasion, the chair of the Regulatory Policy Committee. So over to you, Stephen.
Thank you very much, and thank you for inviting me today to this webinar. As you said, I'm the chair of the Regulatory Policy Committee. That is it's important because it's the independent better regulation watchdog, but it has a rather low profile in terms of our role, which is scrutinising evidence and analysis in impact assessment in order to support government consideration of regulatory proposals when they're presented to Parliament. So we produce opinions on impact assessments that departments are required to produce that set out the costs, the benefits and the risks of particular regulatory measures, and we assess whether they are fit for purpose or not. We've also validate the BIT, which is the business impact target, which is the cumulative cost of all regulations on businesses across the lifetime of the Parliament. And we formally either red rate if they're not fit for purpose, or green rate if a impact assessment is fit for purpose, based on the assessment of the net costs to business and the investigation of the impact on small and micro businesses. We also comment on other parts of the impact assessment, like the objectives and rationale, the cost benefit analysis, the wider impacts on trade, on competition, and on the environment, and the monitoring and evaluation plan. So you can see later on whether actually it has achieved its objectives, or whether there have been any perverse or undesirable side effects or unintended consequences. But we don't comment on policy, we only comment on the evidence and analysis. So it can be a very good policy with poor analysis, and we would still rate it red, or it could be a rubbish policy, but if it's got good supporting analysis, it would be rated as green and fit for purpose. And a minister can still, a democratically elected government, can still move forward with red-rated impact assessments, but that has to be disclosed to Parliament, and obviously ministers are not keen to have to comment when they're presenting their bills to Parliament that their analysis is rated not fit for purpose. So having looked at the Bingham Centre Report, at the RPC we're also very concerned at increasing instances of the compression in the policy development timescales. That means that impact assessments and our opinions may not be available to Parliament in time for their consideration. And even though we do all we can to expedite our investigation, there's only so far they can be compressed. And a good example of that is the recent high-profile case of COVID vaccinations being a requirement of deployment in healthcare services. So the regulation that required all healthcare workers, whether in the NHS or the private healthcare practices, to be double vaccinated. That came to us very, very late in the development process, only a couple of weeks before it was due to be presented to Parliament. And normally, where we see something that has poor evidence and analysis, we issue an initial review notice and send it back to the department and point out where there are weaknesses in their analysis, and and then they go and they redo it or improve it and hopefully manage to get to a green rating. But unfortunately, there wasn't enough time to do that. And while I may not disagree with the policy of having vaccination as a requirement of working in healthcare services, given this significance, I mean, they estimated that around 126,000 people were expected to lose their jobs as a result of this, and causing significant disruption to private hospitals, private GPs, dentists, etc., in an already tight labour markets, already facing staff shortages. That sort of measure needed far more analysis of the consequences for the delivery of the services and the consequences for those businesses in order for us to green rate and approve the impact assessment that was supposed to be supporting the parliamentary bill. Another aspect of the pandemic, which you also raise in the report, is the short-circuiting of the processes that are there to help ensure good lawmaking. As I said, so the role of the RPC, the Regulatory Policy Committee, is to scrutinise and comment on the quality of the analysis. However, there is one of the exemptions from the Better Regulation framework is for temporary legislation. That's legislation that's only supposed to last for less than 12 months. And you can understand the rationale for that, because typically short-term legislation has limited impacts. There's a sort of proportionality argument that it's going to take more time and more energy and more resources to undertake the analysis than for a relatively limited measure. However, of course, the COVID measures were some of the most severe and restrictive measures that we have seen introduced by any peacetime government. Nonetheless, because initially they were expected to last for less than 12 months, they were exempted from the scrutiny process, and there was no impact assessment and no RPC scrutiny of the evidence and analysis supporting it. And even when it turned out that many of these measures were going to last for longer than 12 months, and where they should have had a retrospective IA in order to see, sort of going forward, what the costs and benefits of continuing this was, and to inform further measures, that requirement for scrutiny for temporary measures beyond 12 months was also relaxed by a ministerial measure. And so some of those very significant measures did not come to us. And many of the costs and benefits, the restrictions, the lockdowns of the first restriction could have very usefully informed discussions about the second and third lockdowns and the other plan Bs, etc., and subsequent restrictions. So, for example, do you choose between closing down gyms or nightclubs or hairdressers or pubs? Each of those has healthcare benefits, but they also have separate and different costs to business. And those costs for business and the COVID restriction benefit should be weighed against the cost to businesses, to consumers, etc., in terms of the application of the regulation. And in terms of the restriction, what you get is the RPC reviewing small measures like, for example, the cost to restaurants and cafes of calorie labelling in order to address sort of obesity measures, and that being in the business impact target, the total cost of regulations imposed by government. But the cost of closing down a restaurant or cafe for 6 months is totally excluded. So we don't see the full cost of government regulations on business. And I certainly understand why decisions were made quickly at the start, but believe that there was an opportunity later on in the process to review that and think further about how the measures were going to be rethought, whether they were going to be extended, and how new measures were going to be framed. Now, looking ahead, a government is currently in the process of reviewing the better regulation framework. They consulted last summer on various proposals for changes to the framework, and we're waiting for their conclusions and proposals. In the RPC's detailed response, we made the case for retention and extension of independent scrutiny, earlier engagement in the scrutiny process, so that we can see the proposals and comment on the evidence and analysis earlier, pre-consultation, before the decision is being made, rather than after the minister has made a decision and is being presented to Parliament. A focus on evaluation post-implementation, so that we can see where measures are working well, where measures perhaps have unintended consequences, or maybe the need for a measure has changed or is no longer valid, so that measures can be either retained, revised, or revoked. And also pointing out the point about the temporary exemptions, removal of some of those exemptions from the framework, because they act against the whole purpose of the approach to scrutiny of regulation. And very much hope that the BEIS will take on board our response, and I'll be working with the committee, the RPC committee, in future to implement the impact, the changes to the better regulation framework that are introduced. So thank you very much, and I look forward to discussing the Q&As later.
Thank you very much, Stephen, for that also fascinating discussion. Our next speaker is Baroness Bakewell of Hartington Mandeville, a Lib Dem spokesperson for the Environment, Food and Rural Affairs in the House of Lords, and also a member of the House of Lords Secondary Legislation Scrutiny Committee since July 2019, the one committee in which the policy behind all of the SIs that come to Parliament is examined carefully. So delighted to hear from you today, Baroness Bakewell.
Thank you for inviting me to speak today, and it's a great privilege to be taking part with such knowledgeable experts. I joined the Secondary Legislation Scrutiny Committee in an attempt to understand the passage of an SI
Baroness Bakewell, your microphone is waving out slightly. I don't know if there's anything that can be done to adjust it, perhaps.
Is that better?
It's perfect. Thank you very much.
Okay. Yes, the Secondary Legislation and Scrutiny Committee is extremely lucky to have brilliant officers to guide us through the complex process. And coronavirus has had a dramatic effect on the legislative process. The government made announcements on the steps of Downing Street or at their daily television briefings. Statutory instruments were laid to deal with attempting to stop the spread of the virus and were often operational from midnight on the day they were announced. It is probably going a bit too far to say that chaos reigned, but the effect was not smooth or efficient governance. Even considering the fact that the country, and indeed the whole world, had never been in such a situation before, where it was at the mercy of a virus, the resulting information, counter-information and misinformation was very confusing for both the public and parliamentarians. In the parliamentary session 2019 to 21, the Secondary Legislation and Scrutiny Committee published 54 reports, considered 1,227 instruments, of which 405, approximately 35%, were affirmative SIs, and 822, 67%, were negative SIs. The committee drew 85 instruments to the special attention of the House, in line with our annual average of about 7%. Of these, more than usual were on the grounds of insufficient explanation. And in our report of our 22nd report, there was an example about electric scooter trials and traffic signs. In paragraph 7.4 of the EM, the DFT asserted that e-scooters could be a convenient and clean way to travel that eases the burden on the transport network and allows for social distancing. The committee asked, could they also be a hazard for other users of the road, cycle lanes and for pedestrians? And it is unclear what the policy objective of this instrument is and how its outcome will be measured. Is it a pilot scheme to test the viability of controversial vehicle on British roads? Is it a rapid means to expand transport capacity in cities all over the country during the coronavirus pandemic? And are those two objectives compatible? The committee went on to say the House may wish to ask the Minister for further evidence to support the DFT's case for scaling up the number of trial schemes and to show whether there is sufficient data on safety, nuisance and the likely cost to local authorities to justify this expansion. The House may also wish to ask the Minister for clarification about targets and objectives of these trials. As it happens, the House did wish to ask the Minister for clarification on several occasions, both at oral questions and when the SI was debated in Grand Committee. The role of evidence is also critical, and in this case, the Minister appeared before us recently to explain her position. In order for the SLSC to properly scrutinise government regulation, it needs more time to scrutinise effectively and not impossible deadlines for the implementation of instruments. In terms of the difficulties faced by the committee in scrutinising regulations, the lack of adequate supporting documents is key. During the run-up to Brexit, there were literally thousands of SIs. It was not unknown for an SI to be laid and debated, then weeks later for the same subject to be debated again to correct errors in the first SI, to add omissions which have been left out, or to correct data. This was not the fault of the SLSC, nor can I reasonably say it was the fault of the sponsoring department. The sheer scale of what was expected to be achieved before the deadline was simply beyond the resource capacity which had been allocated to it. For those of us trying to deal with this, it was not helpful. These comments also apply to the coronavirus SIs, where the legislation was often changing on a weekly basis, although it felt like daily. Often the explanatory memorandum was lacking in the detail needed to make a proper assessment of the purpose of the SI. Having worked on a number of bills since 2013, including the Water Bill, Housing and Planning Bill, And lastly, the fisheries and agriculture bills. I have noticed that insufficient detail is creeping into the bills. Not being a seasoned member of the Lords, I've been amazed at the terms applied to bills of Christmas tree, meaning it is likely to cover more than one area of policy, and skeleton bill, meaning it won't have any real detail, but the powers to provide the detail will be with the relevant Secretary of State. I come from a local government background and know to my cost that if you do not provide the necessary detail for an action you are about to take, which will affect residents either in the way they carry out their lives or in their pockets through taxation, then you will be in for a very rough ride indeed. Transparency and lucid explanation are everything. If this is not present, the public will assume you are deliberately trying to pull the wool over their eyes. What appears to be happening in Parliament is that the executive is attempting to take powers to itself, which results in the two houses being bypassed. I don't believe this is the way in which our democracy was designed to work, nor is it what the public have voted for. The move from primary to secondary legislation is a result of a general strategic shift by government to have more control. Primary legislation takes up more parliamentary time. Secondary legislation takes less. This does not address the fundamental issues relating to the principles of parliamentary democracy which ministers should consider, namely parliamentary sovereignty and the accountability of the executive to Parliament. Then there is the issue of guidance versus legal requirement. In the context of the pandemic, where regulations came into force with little or no time to prepare for the new restrictions, and where regulations arrived frequently, it was even more important for the guidance to clearly delineate between what was mere advice and what was a legal requirement. In paragraph 3 of the SLSC report, Government by Diktat, the Office of Parliamentary Counsel states that it is committed to promoting good law, which it defines as law that is necessary, clear, coherent, effective, and accessible. The SLSC endorsed this definition and the OPC's aim of making legislation more accessible and understandable for UK residents. My view is that this is not happening at the moment. The quality of the explanatory memorandum is critical. Sadly, there is often no impact assessment, with the wording saying it was not needed, or a previous IA from years before was still extant. This does not inspire confidence in either what the impact will be or whether the writer of these words had fully understood the impact. This could, of course, not be the case, but the presence of a proper IA could assure readers that what was being asserted was indeed the case. COVID instruments implemented at short notice might have the safety mechanism of a sunset clause. This gave reassurance that the relaxation of some routine safeguards, especially around children, would be reviewed. In particular, I was concerned about the suspension of visits to children's homes where looked after children were placed, and the Ofsted inspection of schools. Clearly, the latter was not an essential activity, but could be suspended for a short period. However, I was concerned when some of these short-term SIs returned to be made permanent without proper debate taking place by Parliament. The use of a sunset clause is a safety net providing reassurance, especially during the epicentre of the pandemic. Finally, the SLSC endorses the DPRRC's recommendation that the Cabinet Office Guide to making legislation should be amended to include a statement of principles governing any decisions by ministers and require them to take account of the principles of parliamentary sovereignty, the rule of law, and the accountability of the executive to Parliament. And I leave you with this thought, and thank you for listening to me.
Thank you, Baroness Bakewell, for that contribution again, which has shed so much light on how the process is working within Parliament, and also indicating the chorus of criticism that's coming from within Parliament as well. We next turn to Mr. Selvin Brown, MBE, who's stepping in for Ms. Tamara Finkelstein, who some of you may have seen. We are none the poorer for his participation. He was the director of Net Zero Buildings at BEIS and the policy profession board member and SRO for equality, diversity, I believe I should say, and inclusion. So thank you very much for joining us today, Mr. Brown. Over to you.
Thank you so much. I have been in civil service for 32 years across Cabinet Office and a number of delivery departments. I do what I call technical, economic and social policy, so buildings, PPE and pensions. I'll come on to that. As you say, I'm standing for Tamara Finkelstein, who is both the permanent secretary of DEFRA, but also for this purpose, she's the head of the civil services policy profession. The civil service policy profession consists of about 30,000 members who deliver, design and propose policy interventions, advise ministers on their priorities and how to implement those. I'm one of 8 SROs in the policy profession, and as you say, I lead the diversity and inclusion strand. Can I thank the Hansard Society and the Bingham Centre for this opportunity to speak to you on such an important issue as the rule of law during coronavirus. I also want to acknowledge from the outset the central argument that recent legislation has been subject to too little scrutiny, has been introduced too quickly and accompanied by too little explanation. My talk will be confined to policy and legislative capability of the civil service, but I do have direct experience for the 5 months from April last in 2020. I was the policy director and engagement director at the Department of Health and Social Care for PPE, working for Lord Dighton. I drafted and devised the face covering policy. We may get into that. And prior to that, I was the policy director and engagement lead for the board of the Health and Safety Executive and drafted much of the regulatory strategy and engaged with the RPC in relation to the BIC and the IAs. I think there's a bit of context before I get into the main thing that I wanted to say, which was if we go back to March 2020, clearly the economy contracted by the largest amount in record history, a large number of people being laid off, and the government had to take measures. It laid 565 corona-related statutory instruments before Parliament. The first 2 of these were laid on the 28th of January and the 10th of February, respectively, and from early March, they had been laid at a rate of about 6 per week. I think there is probably a key aspect of what we are discussing here is the made affirmative procedures which the government used in relation to coronavirus SIs. There were 116 of that over 500, and 98 of those, or 85% of the 20%, were made using the minister's powers, the health minister's powers conferred by Parliament under the Public Health Control for Disease Act 1984. And an example of that has already been touched on, which was the regulations which protected people from being evicted from homes, and absolutely they're working in housing and buildings. We know the evidence shows that a disproportionate number of BAME families will be in the private rented sector. So to the policy profession has recently updated what we call the policy profession standards. It is built around 3 pillars: democracy, so understanding, support and good governance; delivery, designing policy implementation; and strategy, the use of good evidence and analysis. And so I will speak about these 3 pillars and then say some concluding remarks. So under the democracy pillar, I'd emphasize the importance of how we are developing civil servants' parliamentary capabilities to ensure that we support the government to be accountable to Parliament, and that we are able, by supporting ministers and working with Parliamentary Council, to define as has already been discussed, good law as necessary, effective, clear, coherent, and accessible. And we're all committed to that. We believe that we are working collaboratively with the Cabinet Office capability team and the Public Bill and Legislation team to design and develop and deliver training. Since April last year, over 500 civil servants have had direct training in the central team on secretary legislations, and over 265 have received training on explanatory memorandums. These are supplemented by training which is provided in departments. So in BEIS, we have an extensive program of training with activity taking place weekly. The Policy Profession Board is meeting next month to discuss what more we can do in this regard. Under the second pillar, delivery, I'd like to emphasize the importance of clear policy design. Careful, thought through policy delivery requires us to consider risks and to develop legislation to avoid confusion and to ensure that the powers that are required or asked for are appropriate and very focused on the objectives of that policy. I think on the strategy strand, I would say policies and legislation can be made more accountable and effective through robust evidence. So an example of this is when I was at the Department of Health working on PPE, we used the PSED and the impact assessment to assess the impact of our PPE procurement. And we particularly focused on trying to ensure, for example, that we procured clear masks for people who were hard of hearing and different shapes of respirators to go on, particularly round BAME faces. And that is something that we're increasingly doing, and we are using those case studies, those examples of how we can use the evidence to look at the end user and the different types of users and the impact of the policy to make sure that we mitigate from the worst excesses of disproportionate impact. I want to say that not only is the training really important, but also working very clearly with ministers to make sure that legislation which is passed, not just now through the pandemic, but in future, receive the appropriate level of scrutiny. I look forward to the remainder of the debate.
That's terrific. Thank you, Selvin, for that insider's account of how it works, of those who are actually writing these SIs and put forward for scrutiny. Let me thank all of the speakers for staying well within time, which gives us a healthy amount of time for discussion. And I'd like to turn to that discussion immediately. The first question we have from Ronan Cormacane from the Bingham Centre of the Rule of Law. And the question is, although in the short term voting down a COVID SI would have produced problems, question is whether in the long term it might have been better if one or two had been voted down to ensure that Parliament was not simply being taken for granted. I'll put that question to Mr. Justin Matters, if I can.
Yeah, thanks. It's a good question because it was one that we gave consideration to on a number of occasions. I think that there are a couple of things I'd probably say in respect to that. First of all, it probably exposes the limitations of statutory instruments. You either support them or you don't. And in a pandemic, when the government is saying these are the measures that the scientists are advising are necessary, or these are the measures that we can afford to lift, and of course we all want the economy back open, you can't really pick and choose which bits you don't like unless you think the government have got it completely wrong. And whilst we would say certainly they were a little slow or misguided in terms of the timing on occasions, the overall thrust of the policies was not something that we disagreed with. So I think voting something down on what we'd say were procedural grounds would not, I think, have been the responsible thing to do. I think it would have, probably everyone on this call would have understood the reasons, but I suspect the general public would have been very angry with us. They would have seen that as being, playing politics and procedural games on a matter of national crisis. And actually, although I probably had some help from Conservative backbenchers, a lot of the concerns that we raised, particularly about the timing and the way these measures were introduced, was taken on board by the government. So as you know now, all the new regulations that have a national impact are debated in the chamber before they become law, which was certainly an improvement on where we were this time last year.
Thank you very much for that. Our second question is from Madeline Stone, and I think I'll be asking Baroness Bakewell if you could address this for us, please. The question is, how can MPs stop the abuse of the urgency procedure in Section 45, making regs under Section 45 of the Public Health Act 1984? It's been used over and over to rush through controversial SIs, even when policies had been announced weeks in advance. One of the issues that Madeline Stone raises is that whether or not an SI is urgent, and therefore the made affirmative procedure can be used, is left in the minister's discretion. Do we need to reform the Public Health Act of 1984?
Thank you. I'm not sure whether the Public Health Act needs to be reformed, but there is certainly an issue around made affirmatives. And as Justin referred to previously around the SIs, they are an all or nothing instrument. If you vote it down, then it's dead. And that is something which you have to think very carefully about, because the last time the House of Lords did that, we got into quite a lot of trouble, and there was a review into the way in which statutory instruments were dealt with. But it is unhelpful that things are dealt with in the way that they are, and there certainly needs to be a review of how much time is allowed for instruments and regulations to make sure that what appears to be an abuse of the system is not promoted.
Thank you, Baroness Bakewell. Two questions I'll direct to Mr. Stephen Gibson. The first comes from Barney Jackson. The question is whether there's a clear enough distinction between what constitutes due process in pre-legislative scrutiny in normal times compared to times of clear emergency, such as a pandemic. And I think not just for pre-leg scrutiny, but scrutiny of SIs, I assume. The second question is from Karine Gilberg, and it is this: what are the precise impacts of time compression on the impact assessment's quality? So in France, she reports, they're facing the same evolution, and impact assessments are still very voluminous, 600 pages for major bills, which is counterintuitive. So is there a severe impact on the quality of IAs due to time compression in the pandemic? Thank you.
Thank you. Both very good questions. So in terms of the impact of time compression on IA quality, I mean, yes, it is clear, and the example I gave you during my presentation about the COVID vaccination as a condition of employment, one of the factors that has one give as a mitigating factor for the Department of Health was that this was rushed through at a great pace. So it does impact on the quality. We don't tend to see 600 pages. Typically, you're talking of 50 to 100 pages in terms of an IA, fortunately, although there are some annexes. And we do think about what it's reasonable for the department to present, both in terms of what analysis is available, what evidence is to be available, or what would take a long time or be disproportionate in terms of cost to support the measure. But there is a sort of minimum level, particularly as where regulations have more significant and more substantive impacts on businesses and on the public, then we would expect the government to put forward and departments to put forward more robust evidence to support it. So there's a sort of proportionality principle which we set out, where the larger and the more impactful the policy, then the greater the weight of evidence supporting it we would expect. The second question you asked was about, is there a difference between due process in normal times and in pandemic times? Well, in a sense, there is the government uses various routes more often in emergency times than in normal times. So, for example, the COVID exemption, sort of the extension of the temporary exemption was justified partly because we were still in a sort of emergency pandemic environment. There isn't a set change, as far as I'm aware, to the requirements, but we do obviously take account of the same sort of proportionality ideas of does it all need to be supported early on, but we do allow departments to come back and provide further evidence, indeed after the fact, and that's particularly useful where you're thinking about potentially waves of a pandemic and therefore waves of different government measures. So as I mentioned, thinking about the second and the third wave and the sort of restrictions that were imposed there in the light of the experience we had in the first wave and what was successful, what had particularly significant impacts on businesses and what was less. And that was the thing that was really not grabbed, the opportunities that was not grabbed in terms of defining the ongoing legislation in the pandemic programme.
Thank you, Stephen. And very quickly, we had a follow-up question from Paul Evans that is for you clearly. Could the RPC process be broadened out to a wider range of SIs, and how is Parliament made aware of its recommendations and reservations? In a nutshell, if you could address those, I'll move on after.
Yeah, so I mean, we publish our opinions on our website, and they're linked into the impact assessment, and they are presented to Parliament alongside the impact assessment. So that's how Parliament is made aware. Of course, they could be broadened to a wider range of SIs, and one would need to think carefully about the resources that are involved. But certainly, that option is available. Has that sort of answered that for you?
I think so. Thank you very much. We have two questions I'd like to put to Selwyn Brown. The first is from Baroness Hamwi. She asks whether it's feasible to have a more detailed statement of the policy background in the explanatory memorandums prepared for the SIs. She didn't ask if you could answer this, but it struck me as something you might shed light on, because it was also something mentioned in Baroness Bakewell's presentation, that more about the policy background is needed in some cases. The second question from Kirsty Blackman asks whether there's ever been an assessment done on the accuracy of the contents of some of the accompanying documents, namely the explanatory memoranda and the impact assessments. And I wonder whether that's been done either externally by Parliament or internally by the civil service.
So, I mean, firstly, I would say three things. The first thing I would say is, if we take the face coverings policy and the regulations that go with those, I remember, we worked through the night. We did shifts in the team to get that policy and the regulations. The face covering policy was designed initially to prevent PPE being used generally in the population, and then later it was used to help keep workplaces open. So the policy intent changed during the course of the pandemic. The second thing I would say is that the government is absolutely committed in this area. It does agree with the broad principle of the other aforementioned reports that bills should not have sweeping powers, and that there needs to be more precision. And the government will be responding in due course, possibly in a few weeks, in relation to these reports. I think that there is more that we could do to make the explanatory notes, which is, if I go back to my time in 1999 when I was the parliamentary clerk for House of Lords reform bill, the explanatory notes conversation has been an ongoing one. I think it's important to distinguish what are the innovations, lessons that can be learned from the coronavirus pandemic scrutiny and taken generally into how Parliament scrutinises SIs explanatory memorandums and therefore government policy.
Thank you very much. Stephen, did you want to add something here?
Yes, just you mentioned how what we can say about the accuracy of impact assessments. Now, as well as the RPC scrutiny of the impact assessment when they're presented, there is also the post-implementation review, where the department is required to review the how effective the regulations has been, how far they've met their objectives, and the quality, whether the forecasts and the estimates have actually come to pass. And in doing that, and in the RPC's review of those impact assessments, they allow you to feed back and learn the lessons of where you made various assumptions about particular markets or particular ways regulations would work in one case, to learn those for the future. Now, one of the drawbacks of that is RPC post-implementation reviews, even though they are a requirement for virtually all measures, are sort of not very well done. Less than 40% of all regulations have the PIRs are done for very understandable reasons, in terms of that's not where government ministers focus, that's not where how civil servants get promoted, by looking at past measures and pointing out the failures of previous policy measures, potentially by your own department and by other members of your department, isn't a useful way forward. But the trying to find ways to improve the evaluation process of government, so that it really does look at, how did we do? Were we thinking the right way? Can really sort of inform the development of new government regulations and processes.
Thank you, Stephen.
Stephen, we did do PIRs at HSE, as you will probably recall. So we do agree with you.
Great. I have one final question, which is incredibly important, which I think everyone participating here would like to hear some words on. I would ask if Mr. Matters, Baroness Bakewell, and Selvin Brown could have a go at trying to say something about this within an envelope of about 2 minutes for all of us, because that's how much time we have remaining. The question comes from Paul Silk, no stranger to the Constitution. How concerned are panelists that the precedent set during the pandemic for greater use of SIs in general, and made affirmatives in particular, will become normalized? And I can say from the academic field that the great concern with emergency powers in comparative studies of emergency powers is that the innovations do become normalized and bed down. So let me go to Baroness Bakewell first, and then.
Thank you. I am extremely concerned that we are moving to accepting the way in which things were done during the pandemic.
We're having trouble hearing you at the moment, so whichever.
Okay. Is that better? I'm extremely concerned that we are expecting and accepting the norm for things that were done during the pandemic, and that should not happen. We should not be treating it as though we're going to carry on the same. We need to review and re-establish the difference between the executive and Parliament.
So an extreme concern that requires us to conduct a serious review, and presumably the Hallett review will provide an occasion for ensuring these things don't bed down. Thank you very much. Justin Matters.
Yeah, I actually think we've been travelling down this road for some time already. Certainly when we were preparing to leave the EU, there seems to be an awful lot more enabling acts which gave the power for the Secretary of State to make various decisions under delegated legislation. And in my last act as Shadow Health spokesperson, we did the Health and Care Bill, which had, I think, about 60 powers created for the Secretary of State under delegated legislation. So I think that the direction is very clear, regardless of the pandemic.
Thank you very much. And Selvin.
I think time will tell. Obviously, the pandemic is still ongoing, and I think, as I say, the government will shortly set out its response to the 2 other reports, and I think that would be an opportunity for everybody to take stock, including parliamentarians and academics. Thank you.
Thank you very much. Due to the extreme brevity and concision of our panelists, Stephen, I think we do have a bit more time for our last view, although we're 1 minute over. So if you can be prompt, that would be great.
Yes, so of course, we're concerned that emergency powers and emergency exemptions, etc., will be normalized. And I think that is really the challenge going forward, is to make sure we find out what the new normal way of working will be, so that we can move back to something which does introduce good governance processes and does really sort of ensure that we have proper scrutiny and proper consideration of our rules, because they can have very significant and considerable costs to society, to all parts of society, and getting the rules wrong can have significant impacts on our society, on our economy, and on our population. So really important we do that.
Thank you very much. I'd be remiss in not pointing out that the Hansard Society's Delegated Legislation Review is examining precisely this question, among others, and the longstanding question about how to reform scrutiny of delegated lawmaking in the UK. So I think that Mr. Silk and anyone else who is also very concerned about this should keep an eye on the Hansard Society's work, as well as, of course, on the Bingham Centre's constant careful scrutiny of all of the delegated lawmaking, not just for COVID-19, but overall areas of the Constitution. So I'd like to thank all of our panelists, and I'd especially like to thank Dr. Tom West and Katie Lyons for putting together this wonderful panel and a detailed briefing that led to such a focused discussion. So thank you very much, and we hope to see you again soon.